Can I refuse to join a union at work? When we hear about unions in the workplace, one question often comes up. Do workers have to join a union once it's formed? Some employees want the benefits of collective bargaining but don't necessarily want to be union members. Others may disagree with union leadership or prefer to remain independent. The truth is, under U.S. law, workers have both rights and choices. Section 7 of the National Labor Relations Act guarantees the right to join a union, but also the right not to join. At the same time, union contracts, state laws, and something called right-to-work rules all shape how this plays out. In this video, we'll break it down clearly. We'll explain what the NLRA says, how union security agreements work, what right-to-work states mean for workers, and what real-world cases show us. By the end, we'll know exactly what our options are when it comes to union membership. 1. Section 7 of the NLRA, freedom to join or not join. The National Labor Relations Act of 1935 gives employees the right to organize, to form or join unions, and to bargain collectively. But Section 7 also gives workers the right to refrain from such activities. That means the law protects not just union supporters, but also workers who prefer not to participate. Example: a group of warehouse workers votes to unionize. Even if the majority chooses union representation, an individual worker cannot be forced to sign a membership card or attend union meetings. That choice is protected by Section 7. However, this doesn't mean workers can automatically avoid all union obligations. Because once a union is elected, it becomes the exclusive bargaining representative for everyone in the unit, including non-members. That means the union must represent all employees fairly, whether they join or not. 2. Union security agreements. Here's where things get more complicated. Some union contracts include what's called a union security agreement. This is a clause that requires all employees covered by the contract to either join the union or pay union dues or fees as a condition of employment. Under the NLRA, union security agreements are generally permitted, unless state law says otherwise. There are different types. Closed shop requires full union membership to be hired. These are illegal under federal law since the Taft-Hartley Act of 1947. Union shop requires employees to join the union after being hired. These are legal federally, but restricted by state laws. Agency shop requires non-members to pay fees to cover bargaining costs, even if they don't join. Example: a manufacturing plant has a union shop agreement. New hires must either join the union within 30 days or pay equivalent fees. If they refuse, the employer may be required to terminate them under the contract. 3. Right-to-work states. This is where right-to-work laws come in. More than half of U.S. states have passed laws that ban union security agreements. In these states, workers cannot be required to join a union or pay dues as a condition of employment, even if a union is present. Right-to-work states include Texas, Florida, Michigan, and many others. In these states, workers cannot be fired for refusing to pay dues. Unions must still represent non-members equally. Employees who opt out still receive the benefits of the contract. Supporters of right-to-work say it protects individual freedom. Critics argue it weakens unions because workers can benefit without contributing financially. Example: in Nevada, a right-to-work state, a casino worker can refuse to join the union and pay no dues. The union contract still gives them higher wages and protections, but the union has fewer resources to fight for improvements. 4. Supreme Court and court decisions. Court rulings have shaped how far unions can go in requiring membership or fees. Case 1. NLRB vs. General Motors, 1963. The Supreme Court ruled that membership under union shop agreements only means paying dues, not full participation. Workers cannot be forced to attend meetings or adopt union beliefs. Case 2. Communications Workers versus Beck, 1988. The court ruled that non-members cannot be forced to pay for union political activities, only for costs directly tied to bargaining and representation. Case 3. Janus v. AFSCME, 2018. In the public sector, the Supreme Court ruled that mandatory agency fees for government employees violate the First Amendment. That means no public employee can be required to pay union dues or fees if they don't choose to. These cases show that even where union security agreements exist, worker rights are protected from excessive compulsion. Chat 5. Practical examples at work. Let's look at how this plays out day to day. In a union shop state, a new employee might have 30 days to decide whether to join the union or pay fees. Refusal could mean losing the job. In a right-to-work state, that same employee could decline both membership and fees with no impact on their job. Bassers. In the public sector, teachers, government workers, city employees, after Janus, no one can be compelled to pay union fees, even in states without right to work. Example: a nurse in Illinois works in a hospital with a union. Because Illinois is not a right-to-work state, the union contract requires employees to pay fair share fees. But a teacher in Illinois, as a public worker, cannot be required to pay under Janus. 6. Worker rights and employer conduct. It's also important to know what employers can and cannot do. Under the NLRA, employers cannot threaten or fire workers for joining or refusing to join a union. Employers cannot interrogate workers about membership decisions. Employers cannot discriminate based on union activity or non-activity. Example: a construction company tells workers they must join the union to get a promotion. That's unlawful if state law forbids compulsory membership. On the flip side, an employer cannot punish workers for choosing to join. 7. Why this debate matters. The right to join or refuse a union is at the heart of workplace freedom. Supporters of compulsory dues argue that unions need resources to bargain effectively. Opponents argue that workers should not be forced to pay for representation they don't want. This debate shapes wages, benefits, and working conditions across the country. States that pass right-to-work laws often see lower union membership, but also more individual choice. States without such laws see stronger unions, but less freedom to opt out. At the end of the day, the law aims to strike a balance, protecting the right to organize while also respecting the right to refrain. So, can we refuse to join a union at work? The answer is yes. Under federal law, no one can be forced into full membership. But in states without right-to-work laws, union contracts may require dues or fees as a condition of employment. In right-to-work states, employees can refuse both membership and fees. And in the public sector, Janus makes all dues voluntary. The key is knowing the law in your state, understanding your union contract, and remembering that Section 7 of the NLRA protects both the right to join and the right not to join. If this video helped clarify your rights, share it with coworkers. Knowledge of our choices gives us the power to stand confidently at work.